Just let me know when everyone's ready.
I will let you know in just a moment. Okay.
Hmm? 3 weeks. We'll have a conversation. All right. Mr. Hippler, it is 3:31.
You ready? Okay. Okay, good afternoon, ladies and gentlemen. My name is Harry Hippler. I'm the assigned special magistrate for these hearings. Anyone that's going to testify, you could please raise your right hand. Okay. Do you swear or affirm to tell the truth and nothing but the truth? If you could please affirm.
Yes.
Great. Okay, go ahead and be seated. This is not a code enforcement hearing to determine whether or not there are violations. That's already been determined in the past. I took the liberties I always do to review the file. I did that before the last hearing, and I did it again because I just wanted to make sure that I saw and read what was there. I do not have a photographic memory, okay? I go, a couple of weeks beforehand, I'll remember basically, but I don't have a independent recollection or a perfect one. So, but I did this yesterday and the like. I went through the tons of prior cases and the like. These matters have to do with not, as I say, a code enforcement matter, but authorization to do that. 162.09 says that a certified copy of an order imposing a fine may be recorded in the public records, and once that occurs, it becomes a lien on the real and personal property owned by the respondent or the owner of the property. It further states, and this is in subsection 3, that after 3 months from the filing of any such lien which remains unpaid, the enforcement board or special magistrate may authorize the local government governing body attorney to foreclose on the lien or to sue to recover a money judgment for the amount of the lien plus accrued interest. That means that after the recording of a certified copy, 90 days, the city can do that. So I reviewed the various orders signed by the Code Enforcement Board, where Robert Janzer, not sure if he's around anymore. Is he still with us?
Yes.
Okay, good. Great guy.
Yeah.
Chair at the time, then it turned into a special magistrate system here as it has in most other cities. So we're going back some years, and I noticed that there was that stamp showing a recording of a certified copy. So that part I've gone ahead and reviewed, applies, and it's been complied with by the town if it wants to pursue the foreclosure action. So my role here is to determine whether there's been compliance, which I'll find that there has been. I mean, I'll listen to whatever evidence there is, and Jeffrey can substantiate that or tell me I don't know what I'm talking about. It's up to him, and then I'll go ahead, make the finding that there has been compliance, but I did review those items and the like. And then after that is done, I'll certainly listen to what your client has to say, although by law, I probably am not required to do that. But as I do in this city, as well as a number of others, tail end of my career, I sit in many different towns and cities. Some of it can be interesting. Some of it is run-of-the-mill stuff. But a lot of really interesting, intellectually curious cases do come up, all right? So, and the like, and I get appealed as well, so that's life. So based on that, that's my opening statement, and if the code officer wants to substantiate whether or not there have been certified copies recorded and the like, you can take it from there if that's acceptable.
Sure. Just for the record, Jeffrey Lewis, Code and Compliance Officer for the town of Pembroke Park, here to mention the cases for Gerald Anderson at 1708 Southwest 31st Avenue. And there's multiple cases, including case number 4400. 4869, 5297, 5523, 6426, 6905, and 9257. And these are all cases that has a recorded lien in regards to that property, all for the same items. Just to sum it up, the total amount that's fine that has accrued is $5,239,059.50.
What was that number again? 5 million?
$5,239,059.50.
Yes. Okay. $5,239,059.50.
Correct.
Okay, and is that amount continuing to be
Accrued.
okay? That's what's accrued as of today, but it continues to be at various amounts: 250 a day, 100 a day, 500 a day, and all.
Correct. As of October 31st.
Yeah. Okay.
And Mr. Hibbler, this is a commercial property, not a homestead property.
Yes, of course. I noticed that. I also went on Broward County Property Appraiser's Office, which I do regularly, and I did in this case beforehand, and it's not homestead. So, and I think the statute says that the action, foreclosure action or damages action, can be levied against the real property as well as the personal property. I mean, that's what it says. So that's what the statute says, and that's all I can really do. In a sense, what I'm doing is really ministerial. What you go out and do with in a future foreclosure action or work something out with the town attorney, that's up to you. I don't get involved in that. Okay. So I did, again, review the photos and.
Mr. Hibbler, if
Go ahead, sure.
I don't know if Mr. Ackley wants to make a presentation or ask any questions,
Yeah.
you'll be able to do so.
Okay, I'll cut myself off. I just wanted to lay the background of what's going on. Nothing earth-shattering here, I'm sure. If you want to make a statement, come on up, and your client as well.
May I just clarify
My own
Your name and for the record and address and all the other good stuff, yes.
Yes, my name is James Ackley. I'm an attorney out of West Palm Beach representing Gerald Anderson here today, proprietor of A&B Recycling.
Right, and your address up in West Palm.
4196 Torres Circle, West Palm Beach, Florida, 33409.
Great, thank you.
And can I just clarify, this hearing, this proceeding is being recorded, is that correct?
Oh, yes.
Very good, thank you.
As far as I know, it's being recorded, yes. Okay.
Would you like to introduce yourself?
Gerald Anderson, A&B Recycling.
Address.
Closer to the mic.
You want the address?
Yeah,
1708 Southwest 31 Avenue.
okay. All right. Go ahead, please, feel free.
Thank you. In your opening, I appreciate it very much. It was very informative. Thank you for that. But I am sure in hearing you that your presentation was not suggesting that the outcome of today's hearing was a foregone conclusion. Am I
No, of
correct with
course
that?
not. I'm going to hear what you have to say, and then I'll decide whether there's going to be an order entered granting authority. And in the past, in several other instances, one in another town, I didn't grant the authority. Okay, so let me hear what you have to say.
That's great. With regard to Mr. Lewis's presentation, there are 7 different cases before the hearing today.
Right.
Those cases date back to 2014.
Right.
And as an opening statement, I'm just going to summarize what I believe my client will effectively testify to here.
Sure, absolutely.
While violations have been cited and in some cases confirmed in the past, those violations have been corrected or repaired, rectified. And they may, in fact, have been repeated. But there is not a consistent, unending stream of a violation. And the fines that have been represented to the hearing, I believe, represent an unbroken chain of violation, not recognizing that, in fact, there have been breaks and that violations may have been asserted and found, but they have been corrected. Any such violations have been corrected. This is not acknowledging that those violations or accepting that those violations were valid or should have been found to have existed, but rather, even had they been violations, they were corrected. And so there shouldn't be a steady charge for fines and per diem until today. The amount of $5 million plus in fines is just untenable under the facts here. I think more importantly, however, the cases before the hearing today represent a real issue with regard to due process and also equity and arbitrary and capricious enforcement of municipal ordinances. We have a business here that was purchased by Mr. Anderson in 1990, I believe. And at that time, the business he purchased and took over was the exact same business he is practicing or carrying out today. It's a recycling business.
Right.
At that time, the property was being used in exactly the same way it's being used till today. The city initially, the town initially denied Mr. Anderson a business certificate or a license to perform his business when he took over from the prior proprietor. And it took actions of counsel on behalf of Mr. Anderson to get the town to issue the continuing business certificate based on exactly the same practices that had taken place by the previous owner, previous proprietor. This business has not changed since well before 1990, and it has been a recycling business, and it has been carried out in effectively the exact same way it's being carried out today. And yet, after licensing the business to carry out recycling, the town consistently cites Mr. Anderson for doing that business, for carrying out exactly the business he's been certified or licensed to carry out. the town doesn't appreciate or doesn't like the way it looks. It's unsightly. It's not aesthetically pleasing. This is a zoning, M1 zoning. It is zoned for heavy industry. It's not zoned to be aesthetically pleasing. It's not zoned to be a park. It is zoned to be exactly what it is, a business. And yet he keeps being cited for carrying out his business. He keeps being cited for having materials in the swale outside of his property fence. And yet other businesses are carrying out business where they have materials in the swale. And this is the same practice that's been carried out since before he took over the business in 1990. In fact, Mr. Anderson has expanded the actual area of his practice, his company, by about 40 to 60%. So he has been able to, or has taken the, there would be less overflow, I guess, into the swale. Yet that keeps being brought up as a violation. The whole issue with parking spots. The parking spot issue has not changed since he took over the business. It's been an issue with the city, but it's exactly the business that was being performed when he bought the business. Nothing has changed. And yet the town is now saying he's in violation. Curiously, in case number 4400, there are violations for health and sanitation violations alleged. There are violations for building and building regulations alleged, but there are also violations for fire code, which I'm not sure how the town is attempting to enforce fire code violations in a case in front of this hearing. I'm not sure that's appropriate. I could go violation through violation, but my sense from your opening is that's not the point here today, and it's not the purpose here today. What I do think the purpose here today is whether or not the town has established a right to foreclose, given its claims that there have been violations and liens have been imposed. My argument would be that, given the fact that the town authorized my client to carry out this business, it should not now be able to foreclose on my client and take away his property because he's doing what they authorized him to do. That's simply contrary to common sense. It's inequitable. Further, given that there are inconsistent enforcement of the ordinances that are being cited as violations against Mr. Anderson, again, this becomes arbitrary and capricious enforcement. And again, it's a due process issue. My client can testify to the hearing today that not only is he being violated for these things, but the others on his street and others in the industry around him are not being cited for these violations. He uses the swale. Others use the swale, they're not violated. He has trucks that pull up to his property and don't enter his property when they unload. Businesses do the same thing. They're not being violated. This level of inconsistent enforcement, again, is arbitrary and capricious and violates my client's due process rights. And lastly, there's been a practice established since before 1990 to carry out this kind of business. The town fundamentally doesn't have the right now to foreclose and take away that business. It has established its rights, it has established the practice, it has established the custom, and the town has no right today to come in and foreclose. They have every right, by the way, to work with my client in order to try to address the issues that do not take away his right to earn a living. They have every right to work with him to try to meet standards that they now want to upgrade to a point, but he still needs to be able to maintain his livelihood, income, create an income for himself and maintain his livelihood based on the business he's been practicing since 1990 and was practiced before he took over the property. Would you like me to inquire as to my client as to these issues?
Question I would have is this, your claim of due process, the fact that we're here in these proceedings, my understanding is, and please re-educate me, he is receiving due process by the fact that we're having a hearing today, all right? And fundamental due process, I didn't write the law in this case. The statutes under 162 say that it's fundamental due process. And they're like, how is this not due process?
When it's not being applied to everybody in the town, when it's being applied after, when these violations are being applied after the town has said, yes, you can do this, licensed him to do this, and now they're saying he can't do this, these are violations of due process. The fact that he's going through a hearing process doesn't compensate for the fact that the town basically gave with one hand and is now taking away with the other. That's the due process violation.
Okay, and your argument about inconsistent enforcement, the last time I looked at this, it seems to me that there's a case out of the 11th Circuit, that's a federal circuit, that really defers so broadly to local governments as to what might be called selective enforcement. It's up to the city, the local government, to decide who it wants to enforce against. All right, I had one recently in another town where I made a ruling, they claimed whatever they claimed, and they filed a case in the U.S. District Court, and the U.S. District Court judge, and it's a very high quality judge, said in its, I mean, it threw it out. I I was concerned that they were going to sanction the attorneys that filed it, but which of course happens. So I don't see how there can be an argument about inconsistent enforcement and the like. And if there is, should not that have been brought up at the code enforcement hearings? Keep in mind that we're in the code enforcement hearings, that is the trial. It's by analogy. The trial is not the foreclosure. Is post. If you don't raise an issue at the local government level before a magistrate or a board, there is a number of appellate court decisions that say that it's a waiver. All right. So how can you now make those arguments when they should have been made if they were applicable after the fact? And it's furthermore, and there are like 2 or 3 questions here, there were times when I noticed the final orders were entered and your client never even showed up at the hearing. Okay? There are a lot of times. So, if you want to get, there's no court reporter. Why don't we get the invisible court reporter to repeat each of those and educate me about that?
If I may briefly just respond.
Yeah, sure.
So, as far as the one point I was going to bring up is the fact that, yes, that all the prior orders were already entered. Yeah. And they were entered, obviously, a number of years ago. Some go back to 2018, and then all the different cases through the different orders throughout, again, multiple hearings in each of those cases. Go back a long time as far
Before
as...
2018, I think there were several.
Yeah. So as far as the process is concerned, multiple of these cases were available as far as the process. And furthermore, and I believe in 3 of the cases, the town actually already received in 2022 authorization to foreclose. We're bringing all these together to bring everything together and to be more out in the open and put everything together in our efforts with Mr. Anderson to remedy these violations. But again, as you correctly stated, our argument is the fact that we have the certain elements as far as the permission to foreclose, which we've hit, which you articulated, which are in 16209. And then also on top of that, again, the prior orders were already entered. They were entered to the magistrate. They were then subsequently certified again, whether it be by the code board and or the magistrate at those particular times. They've all been recorded. So here is just those particular matters. And we always take any concern regarding selective enforcement extremely seriously, even though this is not the right forum. We're always willing to, when there's something going on, if you let the town know, we're happy to go out and look and enforce it, whatever we can do. The as far as throughout the years, we're happy to do so. And then even now, if there's something going on, we're happy to review it regarding anyone down the street regarding this particular issue. Again, as we've always stated, it's a matter of looking at the property, the evidence we have, and we're happy to always investigate anyone as far as any other business with the hundreds of cases that we have going throughout the city regarding people operating incorrectly. So we're happy to, we have multiple of enforcements. I don't know if any on that particular street, but throughout the entire town that we're happy to share. And if there's anything that we can further investigate, if you can give us a name and address, which is required under the Florida statutes, then we're happy to go out and conduct that investigation.
The other thing is there's no, that I'm aware of, any statute of limitations which would apply before a final order is entered. These orders, once they're recorded and certified, they're good for 20 years, okay? In fact, I would know that because I once wrote an article in the Sets and Law Journal where I thought that for a foreclosure, it would be 5 years, and I lumped it together, thought it was 5 years, but the fourth DCA in its its wisdom, said it was 20 years, okay? And I don't have the site on me, but it is 20 years. So this is all well within the 20 years as well. So, even though I don't have to look at any of the prior facts and the photos of what the business, it's metal. It's not supposed to be junk. It is a sort of, I won't call it junk, but it's metal.
It's metal and plastic and glass, all types of
I
materials.
know, which is a very good business to be in, all right, quite frankly, for Mr. Anderson's sake. But again, when code provisions are enacted, that doesn't mean that a party can just go, if you will, hog wild and do whatever they want to do. The photos are, that I saw, and I got through them, and I've got copies of some of the ones here. I don't need to share them with you, but if you want to, I can, and I made copies of a number of the orders. But, unsafe area surrounds complex business, office. That's just one thing there. He knows what I'm talking about. But we're past all that, okay? So, and these are issues that should have been brought up before the entry of the final order, which is the same as a final judgment with the same power. 162 was enacted by the legislature. They turned these final orders into they're judgments. They're subject to execution, to applicability, to attachment. It's not homestead, all right, obviously. So that's why, you can have your client testify, and that'll be fine. But I'm just asking those questions because I want somebody to re-educate me, unless I happen to be wrong. I'm not perfect, okay? You want to have him testify? Or?
May I have a minute with him first?
Oh, sure, absolutely.
Thank you very much.
Sure.
Very briefly, Your Honor,
Sure.
I'd like to ask Mr. Anderson just a couple of questions.
Sure.
Can you please explain to us, as you've heard, there were some hearings held, some code violation hearings held that you did not attend. Can you explain why you didn't attend those hearings?
If I corrected the matter, then I didn't need to attend. So if I was, if I did that,
Microphone closer to your mouth. It doesn't bite. Okay.
yeah, it does. If I corrected the matters, I wouldn't attend to a hearing. So it's the reason I wouldn't show up. I correct, like I told Mr. Lewis, whatever there's a problem, I address the problem. If the problem is corrected, then I don't need to come to the hearing.
Okay.
Did you have representation for those violations? In some cases,
Probably some cases.
but not in all?
Not at all, no.
And did you come to hearings when you hadn't corrected the violations, the cited violations?
There are times I come here, yes. If I hadn't corrected something or didn't meet the time frame that was given to me. So I have come.
And you've made the effort to comply every time a violation
Every
has been
time.
made?
Every time. We just recently had one. 11, it's not here. Earlier this year, Gene Gustav, oh, I should have it here. Just gave me a compliance and corrected the issue, whatever it was. I should have it here. Well, what I'm saying is that if there's an issue, I jump on it. I try to correct it ASAP. Not saying,
Gene Guston?
Gene Guston. Gene Guston, it says, he have personally examined the property described below and find that said property is now in compliance with ordinance shown below. So this was for case number 10511, and I was looking for a date here, but I don't see a date on here. Yeah, that's my phone over there. But I address all issues, and I try to remedy the issue as soon as possible.
Fundamentally, Your Honor, I mean, what we're here today to say is that it would not be equitable to allow the town to go forward with foreclosure. The town has indicated a capacity or willingness to work with Mr. Anderson to straighten the issues out, and he's more than willing to work to keep his business and livelihood. We would ask the hearing to find that foreclosure is not necessary and allow us to resolve these issues.
Okay, do you have any direct of Mr. Lewis or anything? Because I don't.
I, in all fairness, I mean, as far as I could cross-examine Mr. Anderson, but I'm going to respectfully decline to do so. The purpose of this hearing, I mean, he's clearly testified and shown that as far as he's notified of when compliance is achieved. And so saying that he chooses when to attend the hearings, that's his prerogative. No issue putting on the record that we've spoken with Mr. Ackley. The town has always been willing to work with Mr. Anderson to have the property complied. We are asking that you enter the order today authorizing all the cases. And essentially what this is the hammer. What we need to move forward in staff's determination in order to make sure that these issues are timely resolved. We're working on as far as trying to agree to a particular time frame, but you can see again, it's our position. This has been going on long enough and compliance should have happened years ago. So we're looking for substantial improvement within the opinion of the town. But again, that's for our discussions. But again, I freely admit and put it on the record that we're trying to work with Mr. Anderson. We have every intention to do so and to continue to do so. But at this point, we need a good faith effort within the next few weeks, if not sooner, to make substantial progress in complying the property.
Okay. Anything, Mr. Lewis? Jeffrey?
Just to go over the case that Mr. Anderson just brought up, that was January 2nd of 2025 in regards to graffiti. So that was cleaned up and that was closed out completely. The rest of the cases are in regards to the right-of-way, swell area, operation of the business, in regards to not having enough space in order to operate properly.
Right.
So these are the open violations that are continue to occur that needs to be completed,
And they still exist from,
which still exist on the property.
but the
Correct.
graffiti is the one that it was cleaned up and the like. Okay,
Correct.
all right, go ahead.
Very quickly, the fact that in the January case, the graffiti's been cleaned up, it's been found to be cleaned up. Several of the violations we're here before the hearing today on are related exactly to that same issue. Clearly, it's been resolved, it's gone away, it's not an issue anymore. So I just raised that to your attention because it's been resolved, but it's still before the hearing as if it's an ongoing issue.
Okay. Anything else from anyone?
No.
Okay, I've listened to the evidence. I've considered this. I'm going to authorize foreclosure for all the cases that are pending. What the town and Mr. Anderson and his counsel do is really up to you. I don't get involved in that. I just look at the statute, I apply it, and that's really all I can do. Although I have in the past, like today, listened to people who have said what they've said, but these cases have been going on for a long time. There's been no appeal. There's nothing to show that that there was ever compliance other than the graffiti matter. I don't know what Mr. Anderson read from, but apparently it was the graffiti matter. It doesn't matter to me. That's something, but I'm just mentioning it. And my sole authority here is to go ahead and consider whether there's certified copies that have been entered and recorded, which they have, and the rest is really going to be up to the town to do a foreclosure if it wants to do that, to recover money judgment or foreclose based on the liens.
Yep, and that's the one thing I was going to just clarify, that
Sure.
the request is for all lawful action under 16209.
Yeah, okay, all lawful action. All right, one,
But you read it off. I mean, those are the two that are really there,
yeah, what the.
and the personal property as well. But again, it's our hope and understanding
Yeah.
that again, hopefully we can resolve these issues before litigation.
Yeah, I'm including all lawful actions, real property, personal property. It's up to the town to do what it wants to do with regard to foreclosure. It's not up to me. I don't get involved in that, really. Okay. All right. And is there a order that you have? Okay.
Yeah. Do
Okay.
you want to take a look?
Is that the certificate, or that's the order?
That's the order.
Yeah, there's, while you're doing that, City of Riviera Beach versus Jane B. Motel Corp. et al. It's 217, I'm sure everyone, 4th DCA. The recorded order becomes a lien against the land on which the violation exists and upon any other real or personal property owned by the violator. It specifically says that. If not paid within 3 months from the date of recording, the local government may foreclose on the lien or to sue to recover money judgment for the amount of the lien plus accrued interest. I mean, that's the 4th DCA. And then I cite another case, Fellsmere versus Almanza. Anyway, the City of Riviera Beach, 213 Southern 3rd, 1102. Yeah. And then the City of Fellsmere versus Almanza, 380 Southern 3rd, 1199, another fourth DCA case.
Is there anything else to come before the magistrate?
Not today, I don't believe. Thank you for your excellent presentation. Good luck to everyone, and that's basically it. And I'm glad the Dodgers won. I'm a Dodgers fan. So it was a horribly close case, but
Thank you, Mr. Ipler.
Toronto was great too. So
So we're
anyway,
adjourning?
yes, we're going to adjourn.
All right.
I'll sign this, okay.
Mr. Sherman, I'll be in touch.